The Fifth Amendment to the United States Constitution gives criminal defendants a litany of rights. The provision that we're going to look at today is called the Double Jeopardy provision, which provides that no person may, for the same offense, be twice put in jeopardy of life or limb. The Double Jeopardy provision means that no person shall have to go to trial, be found guilty or not guilty, and then have to face another trial. Once the trial is conducted, regardless of the verdict, that's it. However, there is also something called the dual sovereignty doctrine. This tests whether two political entities are separate sovereigns for double jeopardy purposes. If they are separate sovereigns, such as the state and federal government, then the state can put someone on trial, and if they're acquitted, the federal government could then try them on the same facts and the same circumstances and get a conviction. Supreme Court precedent has held for a very long time that the state and federal governments are separate sovereigns for double jeopardy purposes, in the same way that the US government is a separate sovereign from another country. Someone could, for example, be tried under one sovereign, a different country, and thereafter be retried by the government of the United States, and this would not violate the double jeopardy provision. This happened in the Rodney King case back in the early 1990s, when four Los Angeles police officers were initially acquitted in state court of assaulting Rodney King, but were later tried and convicted on federal civil rights charges. It happened again to Lemrick Nelson, who stabbed Yankel Rosenbaum during the Crown Heights riots in Brooklyn in 1991. Though acquitted in state court, he was later convicted on federal court on civil rights charges and served a 10-year sentence. An interesting sidelight that has never been decided until 2016 was whether Puerto Rico constituted a separate sovereign from the United States government. This is because Puerto Rico is not a state, but rather a United States territory. To understand this, we want to get a little background. In 1898, Spain ceded Puerto Rico to the United States following the Spanish-American War. After that, it remained a territory of the United States. In 1950, Congress enacted Public Law 600, which authorized the island's people to organize a government pursuant to a constitution of their own adoption. Thereafter, Puerto Rico adopted a constitution, and from that, they're self-governing. Puerto Rico versus Sanchez Valley started when the Commonwealth of Puerto Rico enacted the Puerto Rico Arms Act of 2000, which regulated firearm sales on the island. In 2008, Commonwealth prosecutors charged Luis Sanchez Valley and Jamie Gomez Vasquez with violating the Act's prohibition against selling firearms without permits. With those charges pending, federal grand juries also indicted them on federal laws based on the same transactions. Both Sanchez Valley and Gomez Vasquez pleaded guilty to the federal charges because they were much more lenient than the Puerto Rican laws. They then moved to dismiss the Commonwealth's charges, arguing that successive prosecutions on like charges were unconstitutional on double jeopardy grounds. On eventual appeal, the Supreme Court of Puerto Rico agreed, indicating that Puerto Rico is not a federal state. Therefore, it constitutes part of the federal government, and as such, the same sovereign as the federal government of the United States. Therefore, it violates double jeopardy to try them both in federal court and in Puerto Rican court. The U.S. Supreme Court affirmed the holding of the Supreme Court of Puerto Rico. Justice Kagan wrote for the six-justice majority and held that the double jeopardy clause bars the federal government in Puerto Rico from duplicating charges brought by the Commonwealth, essentially ruling that Puerto Rico is not a separate sovereign from the federal government. Justice Kagan began her analysis with a summary that talked about the Fifth Amendment's dual sovereignty exception. Although she indicated that the double jeopardy clause protects a defendant from two prosecutions for the same offense, the exception provision allows two prosecutions if they are brought by separate sovereigns. Justice Kagan's analysis looked at the historical roots of this and held that the doctrine is supported by the, quote, deepest wellsprings of prosecutorial authority, authority that precedes the existence of federal power itself, which even precedes our federal government. With that as a framework, the court determined that the states and Indian tribes qualified as separate and distinct sovereigns of the federal government. On the other hand, municipalities and U.S. territories, including Puerto Rico itself, do not qualify. Justice Kagan conceded that Puerto Rico transformed into a new kind of political entity by virtue of Public Law 600 and Puerto Rico's subsequent adoption of its own constitution. Because of that, it took on characteristics of a state. Still, the dual sovereignty doctrine, the court held, focuses not merely on the fact of self-rule, but also on where it came from. Because the roots of Puerto Rico's power to prosecute lie in federal power, the entities are the same. The doctrine requires the court to go beyond the immediate or intermediate locus of power to the ultimate source. While Puerto Rico is self-governed to an extent, it still governs itself only as an extension of federal power. Contrast this with the states that from the beginning of the country, dating all the way back to the 13 colonies, were their own source of power and did not completely cede their autonomy to the federal government with the United States Constitution. Although joining Justice Kagan's majority, Justice Ginsburg filed a concurrence to question the dual sovereignty doctrine itself. Justice Ginsburg believes that because states and the federal government are kindred systems and part of one whole, allowing both the states and the federal government to prosecute based on the same facts is inconsistent with the spirit of the Double Jeopardy Clause. Justice Thomas also wrote a short separate opinion to note his disagreement with the court's treatment of Indian tribes in its double jeopardy analysis. Justices Breyer and Sotomayor dissented. Justice Breyer's opinion disputed the majority's holding that required the court to look back at the furthest source of power. In his view, the doctrine directed the court to trace the source of the power to a time when a previously dependent entity became sufficiently independent to constitute a sovereign. According to Justice Breyer, Public Law 600 and the creation and adoption of the Commonwealth's Constitution shifted the source of Puerto Rican criminal law from Congress to Puerto Rico itself, its people, and its constitution. Therefore, Puerto Rico should be considered as a separate sovereign for double jeopardy purposes. Under the majority, and thus the court's holding, Puerto Rico cannot convict someone of the same crime if they've already been convicted under federal law. Or alternatively, if someone is convicted or acquitted in Puerto Rico, the federal government can't thereafter pick up the defendant and retry them. Essentially, Puerto Rico and the United States federal government are considered one entity for double jeopardy purposes.